Rule 132, examination of witnesses, section no, ito, 13, 132, examination of witnesses, section 1, examination to be done in an open court. The examination of witness present in a trial or hearing shall be done in an open court and under oath affirmation unless the witness is incapacitated to speak or question calls a different mode of answer. The answer of the witness shall be given orally. Section 2, proceeding to be recorded. The entire proceeding of a trial or hearing, including the question propounded to the witness and his answer there to the statement made by the judge or any of the parties, counsel, or witness reference to the case shall be recorded by means of shorthand and stenotype or by the means of recording found suitable by the court. Transcript or record any proceeding made by the official stenographer, stenophist, or recorded or certified as correct by him shall be deemed prima facie a correct statement of such proceeding. Section 3, rights of obligation of a witness. A witness must answer question, although his answer may tend to establish a claim against him. However, it is the right of a witness to be protected from irrelevant, improper, or insulting question and from harsh or insult demeanor, not to be detained longer than the interest of the justice required, not to be examined except only as to a matter pertinent to the issue, not to give an answer which tends to subject him to penalty of an offense unless otherwise provided by law, or not to give an answer which will tend to degrade his reputation unless it will be very fact issue to which fact issued would be presumed, but witness answer the fact of his previous final conviction of the offense. Section order on in the examination of individual witness. The order in which the individual witness may be examined as in follow: direct examination, cross-examination, direct examination by opponent. B, cross-examination by opponent. C, redirect examination by the proponent. D, re-examination by opponent. Section 5, direct examination. Direct examination is the individual in chief of witness by party presenting him on the fact relevant to the issue. Section 6, cross-examination. It is the purpose and extent. Upon the termination of a direct examination, witness may be cross-examined by the adverse party as to main the matter stated in the direct examination or connected there with the sufficient fulfillment of and freedom to test his accuracy and truthfulness and freedom from interest or bias or reverse elicit all important fact bearing the issue. Redirect examination is a purpose. After the cross-examination of a witness has been concluded, he may be re-examined by the party calling him to explain or supplement his answer given during the cross-examination on redirect examination. Question matters not dealt with during cross-examination may be allowed by the court or the discretionary cross-examination. Upon conclusion of the redirect examination, the adverse party may be cross-examine the witness on the matter stated on his direction examination, and also such other matters may be allowed by the court in direction. 9. Recalling witness. After examination, the witness both side has been concluded the witness cannot be recalled without leave of the court. The court will withhold leave discretion as justice may be required. Section 10, leading and misleading question. The question suggests of the witness the answer which the examining party desires is a leading question is not allowed. On a cross-examination of preliminary matter, when the difficult is getting redirected intangible answer from the witness who ignored or a child tender years is feeble-minded and or deaf mute, unwilling or hostile witness who adverse the party of an offer director or managing agent of a public or private corporation, partnership or association which adverse party. A misleading question is one who assumed as true a fact not testified by the witness or contrary that has previously stated is not allowed. Impeachment of the adverse party and witness may be impeached of the party against whom bad or the evidence that made time statement inconsistent and present testimony but not by evidence of particular wrongful acts except that it may be shown examination of the witness or record the judgment that been convicted of the offense. Section 12, party may not impeach his own witness except with respect to the witness referred to the paragraph. And section 10, the party producing the witness is not allowed to impeach his credibility. A witness may be considered as unwilling or hostile only to the declarant by the court adequate following adverse interest and justice reluctant testify having misled, calling him the witness stand. The unwilling or hostile witness declared the witness of adverse party may be impeached by the party presenting him respect and has been called adverse party except the evidence of his hand character. He may be impeached, cross-examine adverse party, but such examination must be on the subject matter on his examination in chief. Section 3. How witness impeached by evidence of inconsistent. Before a witness can be impeached by the evidence, has made other times statement inconsistent with the present testimony. That statement must be related to him, circumstance, times, the place, person present, and he must be asked whether the made statement allowed to explain them. If the statement has been in writing, they must be shown to the witness before any question concerning them. Section 14. Evidence of a good character of a witness. Evidence of a good character of the witness is not admissible until the such character have been impeached. Section 10. Exclusion and separation of witness. Of any trial or hearing, the judge may exclude from any witness not allowed time under the examination so that may not hear the testimony of other witnesses. The judge may also cause the witness to keep separate, prevent conversing with one another until shall have been examined. Section 16. Witness may refer to memorandum. Witness must be allowed to refresh his memory respecting a fact by written or record by himself or his declaration at a line when the fact occurred or immediate thereafter. Time of the fact, memory in the same as currently written recorded, but writing recording must be produced. It may be inspected by the adverse party who may chosen, cross-examine, written upon, and may it end evidence. So also a witness may be testifying in such a writing or recording thought to retain a recollection of the particular fact if the able to swear his writing recording correctly stated transaction made. Such evidence must be received with caution. Sa ito sa 15 is exclusion, separation of witness. 17. When a part of transaction or writing or record given the evidence, the remainder admissible. When a part of an act, declaration, conversation, writing, or record given the evidence, one party who the same subject may be inquired to the other when detached act, declaration, conversation, or writing record the evidence other than the fact may also given as evidence. Right to respect writing shown by the witnesses. Whenever a writing to a witness, it may be inspected by the adverse party. Adverse party. Classes of document, section 19, for the purpose presentation of evidence, document either public or private. Public documents are written on official record, official act, sovereign authority, official and tribunal, public officer, whether the Philippines or the foreign country. Document acknowledged before notary of the public except last will, lahi ang last will, and testament. Public records kept in the Philippines of the private document required by the law therein. All other are private. Proof of the private document offered as authentic, received as evidence due to the execution. Authenticity must be proved. Anyone who saw the document executed or written, evidence, genuineness, signature, handwriting of the marker. Any other private document need to be identified, claimed to be evidence authenticity on private document not necessary when a private document is more than 30 years old, produced because of the which not naturally found in a genuine and emblem by any alteration, circumstance, or suspicion. No other evidence is authenticity need to be given. How genuineness of handwriting proof. Handwriting of a person proved by the witness. Witness believes that the handwriting is our also because he has seen the person write as the writing purporting is upon each which the witness acted and been charged with the acquired knowledge. Handwriting of such a person's evidence respecting the handwriting may also given by a comparison made by the witness of the court in writing admitted a genuine by the party against whom the evidence offered proved to be the genuine of the satisfactory of the judge. Section 23, public document as evidence. Document concerning entries public records may perform a duty by public order, prima facie evidence of the fact stated in other public document, even against a third party. The fact which gave rise to their execution, date, and the latter. 24, proof of official record. The record public document for the paragraph of section 19 written admissible purpose of the evidence. Five. What attestation? Ito, wala ko balo 133. Right insufficiency of evidence. Preordinance. Evidence how determined in a civil case, the party having the burden of proof establish the case preponderance to the evidence determining where the respondent's superior weight the evidence issuance of the court may consider all the facts. Ano kabalo sa Leviticus 25 turing ka to prove beyond reasonable doubt that a criminal case accused the entitled to be acquitted unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt means a degree of proof excluding possibility and error produced in absolute certain. Moral only require that the degree of proof produce conviction and prejudice mind. Extrajudicial confession not sufficient ground for conviction. Extrajudicial confession made by an accused shall not be a sufficient ground for conviction unless corroborated by the evidence of corpus delicti, circumstantial evidence when sufficient. Basahan naman ako na ba? Basahan naman ako, circumstantial sufficient for conviction if there are more than one circumstance. Gahapon ba na lecture ang circumstantial? The facts infer the difference of proof. The combination of the circumstantial should produce conviction and reasonable doubt. Moro to taman. Hindi na niya ano kabalo. Section 5, substantial evidence. In case of appeals before administrative or quasi-judicial bodies, a fact may be deemed established if it is purported to be substantial evidence that account of a relevant evidence which a reasonable mind might accept adequate justification of conclusion.